undertaking in the next couple of quarterly actually sessions, not just with them, um, but we will continuously be having such sessions as Stratostaff with Kem and Associates being part of our partners. And just as a start, we know that workplace is continuously changing. When we are looking at HR operation excellence, there are things that we know that, when we do our budgets, we put in, we say we will hire these people, we'll have all this. But in the recent past, we've had a lot of disruptions within the workplace. And I know one of the things that we've been facing is SHIF, as one of the things, the transition from NHIF to SHIF that has taken us by storm. Yeah, there is a lot of redundancy. We are seeing companies closing left, right, and center. But what is the future? What etiquette do you need still to have as an organization and as a people to have still maintain your operational excellence, especially for the HR people who are in this meeting? Yeah, how do you still maintain that standard? Because remember, whatever you do still reflects not just on the company, but on yourself. Then the workplace keeps on changing. And as I said, compliance of what was happening 10, 15 years ago is now changing. It's different. The things that we were doing and were being seen as taboo are now being accepted in the workplace. You've seen people with red hair coming to the office. Banks have started allowing people with dreadlocks in, things that our fathers would really frown upon when they entered into a bank. So what has changed within the workplace? And the speakers tonight, William will introduce them later, are speaking to these three components. Yeah. And as Stratostaff, I will do a quick introduction of who Stratostaff is all about. And then I will hand over to Kanano Muteta, who will actually walk us out through what Cost Correct Consulting is and Kem Associates, because they are one organization. Stratostaff has a heritage of a very long heritage, over 20 years, our history. Yeah, it's been over 20 years. And we started off as a unit of Ultima Africa. For those who've heard of Ultima Africa, it was doing consulting work. So about 11 years ago, they set up Stratostaff East Africa to start off doing staff outsourcing. That's where we started off from. And from there, we built up other services, which I'll mention. But in line with that, there are two organizations that have come out of Stratostaff. One is Ultima Talent, which will do definitely the same things that Stratostaff and Ultima Talent is doing, but within the region. So we have presence currently in Tanzania. And in the next couple of months, we will be opening up in Uganda and Rwanda. CMTI Africa Institute, CMTI Clinical Mastery Institute is an upskilling center where we intend to upskill a medical profession, just not just for this market, but also for the foreign market. So those the two institutions, Ultima Talent and CMTI, are both a brainchild of Stratostaff East Africa and Ultima Africa. And what does Stratostaff do? We offer flexible staffing solutions. So we've been doing this for over 11 years. And we look from the start, from your recruitment up to the end. What are those things in terms of HR that we provide? We have served various clients within the region. From your biggest guys, from Total to all that, and you'll see that. And what do? We offer executive recruitment. We offer interim executive management, assessment and assessment centers, graduate trainee programs. We've just finished one earlier in the year for a very good client of ours. We also offer tech talent for those organizations who are looking to moving into the digital area. But our big kid is staff outsourcing. That is what Stratostaff was started off with, and we have been doing this for over 11 years. It's actually what I usually tell individuals is staff outsourcing is older than Stratostaff itself. So these are the number of, not the number of guys, these are some of the guys that we have supported over the years, from your financial institutions, your Fortune 500 companies like Google, Intel, Right now, some of our clients include DP World. Yeah. We have your energy sector individuals. So we have the right expertise and the people and the confidence of our clients who have given the confidence to us to support them. Yeah, so, and that is what we do. And with that brief introduction, I'd like to leave the floor to Kananu Mutea for her to take over the presentation on the other areas. Thank you, everyone.
Thank you so much, Anthony, for that introduction into Stratostaff and indeed the background of how we get to come together. Thank you, everybody, for joining us, and a good afternoon to you wherever you may be sitting. Welcome to the day's webinar, which I hope you will find incisive as we explore with you pertinent aspects of human resource management. Now, with Stratostaff bringing the complement of practicality, we then bring in the practicality touching on law and its evolution. So let me tell you a little bit about KM Associates, which works in collaboration with Course Correct Consulting. We're a niche practice which specializes in dispute resolution, and we have a focus on disputes in relation to employment law. What we look at in this space is workplace dispute resolution. Of course, you know about the disciplinary measures, not just that, but compliance and advisory components as well. What we aim to do is to create efficiencies for organizations. And over the years, what we've done is that we've worked with employees in different and diverse industries, just as Anthony has mentioned, in navigating challenges that are emerging constantly in this space. Whether it's advising on policies or disputes arising from termination or redundancies, which unfortunately we've seen quite a bit of in this year, or the disciplinary processes, we are part of that with a goal to empower organizations and individuals with practical and responsive approaches. We're particularly passionate about fostering equitable workplaces, and this, whether it's with ESG and other directives on governance, we find quite critical, helping clients to adapt to regulatory changes. Today, we want to draw into one of the areas that we find passion in, which is knowledge sharing. And in so doing, what we hope to do is provide you insights that will help you adapt to challenges that we see evolving, judicial pronouncements that we see not necessarily having the tried and tested forum outcomes that you'd expect, but evolving into some of the new dynamics that changes in workforces, introductions of Gen Z are presenting us with to confront. So with that said, let's dive into this. And William, I want to hand over back to you so that you can introduce our very key speakers for this afternoon. Asanteni sana. Bye-bye.
All right. Thank you so much, Kanano. Thank you so much, Anthony, for that introduction. So I'll go straight to the first speaker. And our first speaker is Eileen, who is a dedicated HR practitioner at Stratostaff, where she specializes in managing comprehensive HR functions. And her expertise spans recruitment and selection, training and development, employment, labor law compliance, occupational health and safety, work injury benefits, act compliance, payroll management, and also administrative duties. So Eileen holds a Bachelor of Science in HR Management from Moi University and is also a certified CHRP, and also is currently a member of the IHRM. So I would like to invite Eileen to go ahead and speak on the topic of HR excellence redundancy. Eileen, you're welcome.
Thank you. Thank you, William. I hope that everyone can see my screen. William, can you confirm?
Yes, that's right.
Okay. Good afternoon, everyone, and welcome to today's session. And as William has said, and also as Anthony has said, I will be talking about majorly HR operational excellence with a focus on redundancy in Kenya. And the reason why I chose to speak on this topic is because of the major issues that companies have been facing right now is specifically on redundancy. And specifically in the past 12 months in Kenya, there have been a number of organizations that have declared redundancy. And it's important to be conversant with the topic of redundancy to know how to navigate it while being compliant with the law. And you also need to minimize the impact of on the affected employees, whether they will be retained by the company or whether they will be affected by the redundancy. All employees are usually impacted by a redundancy. You also need to protect the reputation of the organization. You don't want redundancy to reduce the opportunities for future recruitment for the same organization, and also for people to be talking bad about the organization. For those not affected by the redundancy, you need. Is someone trying to speak? For those who are newly joining us, please mute your microphone so that we can be able to hear each other. Thank you. So as I was saying, you need to maintain the employee morale and engagement for those employees who are being affected by the redundancy, as well as those who are going to be remaining in the organization. There's also an aspect of cost management. Redundancies are quite costly to the organization in terms of paying the severance pay, among other things that are required as per law, which we will talk about in a different slide. You also need to minimize operational disruptions in that after the redundancy has been announced by the company, will you still be able to meet production in the case for, let's give, for example, we are working with a manufacturing company. And also it's the ethical responsibility of the employer to also manage the redundancy process properly. So by the end of this session today, I'd like everyone here to have a better understanding of redundancy and its implications, to be able to highlight the best practices for managing a redundancy. You'll also have an insight into what the law says about redundancy, and you'll also have some strategies for maintaining operational excellence during transitions. So redundancy is essentially, in the layman terms, a reduction of the workforce of a company, and it may be brought about by different things. The first thing is that it might be brought about by operational changes in the organization. It may be brought about by technological advancements, or even a company just being in financial constraints. For example, I'll give a very old example of telephone operators. I don't know if anyone here is old enough to remember telephone operators. I myself am not, but I'm borrowing this example from things that I've seen in movies about how it used to operate. There used to be these people called switchboard operators who essentially used to connect. When you pick up the phone, it used to go to a switchboard operator who would then connect you to the person that you want to talk to. And then technology came, and phone companies realized that they don't have to have a switchboard operator on hand, and which led to this being phased out completely. And nowadays, when you pick up the phone, it goes directly to the person that you're calling. So that's just one example of how technology affects a company and leads to redundancy. And redundancy has a lot of impacts, and the impacts are usually both to the organization and to the employees. And remember that redundancy might not mean that a company is completely going to shut down. It may just need a reduction of the workforce, and therefore there might be people who might be leaving and those who are not leaving. And it impacts all of them in a different way, including those who will not be leaving the organization. So there's different aspects. There's the psychological impact, the stress of the person that you've just told that their job is no more, and from a certain date, they're not going to be receiving the salary that they have grown accustomed to and grown to depend on, which will also lead to a loss of identity. There are some people who like to introduce themselves with the company that they work for. My name is Eileen. I work for Stratostaff. And if Stratostaff lays me off, I lose that sense of identity of I work for a certain company in a certain capacity. Another thing is financial consequences. That is the most obvious one. This person has just lost their source of income, which may lead to increased debt. Maybe they need to borrow to be able to cover for the next few months before they get a job. Another thing is a job search stress, which may come as a result of you've just been told you've lost your job and you still need to meet your daily needs. So you're going to start immediately putting your CV in order and sending applications to where you can, which leads to stress because you won't get a response from each and every one of those places that you apply. And those rejects coming might actually start to even cause you a lot more stress. Another thing is some people don't, when they're told that there is a redundancy at their jobs, they will not go and tell their spouses. So even your spouse asking you for money to buy a packet of sugar might cause stress in the household with the relationship that you have with your children, or even with your family, your mothers and fathers at home who might not know that they are being affected by redundancy. And then also the aspect of isolating from friends might also come into play. For the organization, you'll have a financial implication, as I had mentioned earlier. Redundancy is quite expensive for an organization in terms of the payments that will need to be made to the employees, but it is unavoidable. Another thing is the company might get a reputational damage, which could lead to them having difficulty in attracting talent in future. And the remaining employees might also get affected. They might have survivor syndrome, low morale, resistance to change, which might actually lead them to being less productive in the workplace. And also the operations might change. During the transition period, like I had said earlier, it might not be the entire workforce that is being affected by the redundancy, which could lead to some knowledge gaps in that some people who are fully knowledgeable about the operations might be the ones affected by the redundancy, and the ones remaining might not be able to really take up the role of those who are leaving. And therefore, there might be a transition period where the organization might not be doing so well. So what are the best practices in managing redundancy? First and foremost, you have to develop a clear policy for the redundancy. In that, you need to define what will define the employee who is being declared redundant and what will define the employee who is not being declared redundant. You'll also need to have a policy on the people who are being declared redundant. What will they get paid? Will they just get paid the minimum that the Employment Act under Section 40 prescribes, or will the company go over and beyond? I've seen companies that have decided to go over and beyond and even pay performance incentive to the people who have been declared redundant. Instead of paying 15 days for every year worked, some have even gone above and beyond and paid 30 days for every year of employment. So those are some of the things to really think about if your organization is going through a redundancy. Another thing is communication strategy. How are you going to communicate to the employees that they are being declared redundant? Are you just going to pull them out of work, put them in a boardroom somewhere and just tell them and expect them to go back to work? that if you decide to do that, that might not really work for you. And the best practice that I have seen is setting aside a whole day or 2 days and calling the employees to a place other than their place of work. Let's say like a conference facility. Just get a good conference facility, have the employees have lunch, and afterwards, someone from senior management, top management, speaks to all the employees at large. Let them know that the redundancy is coming. Let them know what to expect. And further, break down this large group into smaller groups and still have the same conversation and gauge where they are at an individual level, so that you can have no communication gaps and no no whispers and rumor mongering going around that might lead to miscommunication and lead to reputational damage. Another thing I've also seen is offering support to affected employees. This can be in form of outplacement services and counseling services. And also, a lot of organizations do not have the capacity to do this in-house, and that is why it's better to outsource this kind of services to people who are guided professionals who will actually take the employees through the outplacement sessions and the counseling and training sessions. Another thing to consider is legal compliance. The Employment Act of 2007, Section 40, outlines the procedures for redundancy. After this, you can be able to just Google that, download the document, and Section 40 is where they really focus on redundancy, and read that and be able to understand what needs to be done. From sending the letter to the labor officer, if your employees are affected by a union, consult the trade unions where necessary, and furthermore. Much as you'd like to say that you're going to prepare for a redundancy and not face any challenges, there have to be challenges in everything. The first and foremost thing is about the legal framework. You need to comply with the with the Employment Act of 2007, just as I had said previously. And this is Section 40 of the Act. The employers must adhere to all detailed legal procedures. And another thing with adhering to legal procedures, there is ambiguity in legal interpretation, especially for for people who have not been trained on this. Therefore, it's quite important to seek legal advice from those who are actually able to interpret the law properly, so that you don't find yourself in problems. Another challenge is usually, like I have said, redundancy is quite costly, so it might have economic and financial constraints on the company. We also have cultural and social factors in this society of ours, Kenyan society. Jobs don't usually just impact one individual. It impacts more or less a community or a family. And this might actually amplify the emotional burden. Something else is if you have unionized employees, unfortunately, unions might actually take long with the negotiations, which might actually lead to redundancy, the whole redundancy process being prolonged and quite costly to an organization. And for the employees who will be remaining, you might have survivor syndrome. And basically, the people who remain might have mistrust towards the organization. You might find people trying to look for jobs elsewhere because they're not sure whether after the redundancy is done, they might be the next phase of people who are going to be declared redundant. Like I had said earlier, communication must be done in an efficient way by someone who can be trusted in the organization. And in case anybody has any questions from the redundancy communication, it's always important to guide them on who they can ask their questions so that they can be able to get the correct answer. Another thing is there might be a knowledge and skills gap within the HR professionals because not everyone is well versed in handling redundancies, and this might lead to problems with compliance in the law. Another thing that I've seen happening during redundancies is that if a company has poor record-keeping habits, it can lead to challenges in proving compliance with redundancy regulations. Like, for example, an employee, let's give the employees a name, Otieno. He joined the company in 2007, but there are no records of when he joined in 2007, and the records start from, let's say, 2015. You'd have a challenge in calculating the severance pay of Otieno because of poor record keeping. So companies must adhere to good record keeping so that at least in case of such kinds of situations, you can be able to clearly know how to calculate certain things. Another thing is, so we can talk about the strategies for HR operational excellence. This entails workforce planning, continuous training and upskilling, investing in technology for efficiency, and having employee engagement and retention strategies. I won't dive into this too much, and I can conclude my talk today in that it's important for companies to proactively align HR practices with organizational strategy and to regularly review and update policies, not just redundancy policies, but policies at large as the world keeps on changing. And in redundancy, it's also important to engage all stakeholders early enough in the process. Stakeholders will include the employees themselves, the unions, and any other interested parties like the Labour Office. And an emphasis should be made on the well-being and legal compliance during the redundancy process. A lot of people focus solely on legal compliance and they really forget about managing the well-being of employees. And redundancy is inevitable in some cases, but it can be manageable if you put in the right strategies. And HR operational excellence will ensure that there are smooth transitions and it minimizes the negative impact of reasons. You can feel free to share them in the chat box and we'll tackle them later. Asante sana. And there are our contacts for Stratostaff in case you need to reach out to us. Thank you so much for listening.
All right, thank you so much, Eileen, for that presentation on redundancy. We really appreciate that. So our next speaker is called Julie Mulindi, who is a partner at JM Law. Julie is an employment and labor relations expert at JM Law with almost a decade of expertise and providing strategic advice and dispute resolution support to clients. With a proactive compliance focus, Julie specializes in establishing effective systems to manage, avoid, and mitigate employment risks. When legal challenges arise, Julie provides strategic litigation and tailored solutions by meticulously assessing and mapping the impact of risks to clients' ongoing business operations, reputation, finances, or legal implications to meet their specific objectives. So Julie today is going to tackle more about the SHIF Act and recent legislative updates, and also employer obligations, including registration, contribution rates, and deadlines, and also tackle on implementation challenges and the current status following the judicial reviews. Julie, you're welcome.
Why, thank you so much, William, for that introduction. It's quite overwhelming. And thank you to you and also KM Associates for having me speak on this landmark legislation. Now, of almost all legislation that we've had this year, this has been controversial, right next to the finance bill. And the concern has been mainly the flickering nature of this law, which makes it very difficult for businesses to try and understand, are we complying, are we not complying? And going back to the theme on operating with excellence, it's important for businesses to keep their ear on the ground, for employers to do that, so that they comply. Now, I'm going to start with an overview of the SHIF, the Social Health Insurance Act. I'll say SHIA moving forward. And I'm going to start with why. Why do we have this act? I think it's not been met with a lot of understanding. Now, previously we had the National Health Insurance Fund Act, and this is an act which is almost 58 years old, almost as old as our country. But its main focus was offering coverage to salaried and maybe self-employed people later on. But it did have a lot of challenges, and what it meant is that there were very many people who are not covered under that act, because most people in Kenya are from low-income households. And the result, and based on the previous government and also this current government's focus on universal health coverage, we had the Social Health Insurance Act being passed. And what this act does is that it creates three funds, which is the Social Health Insurance Fund, the Primary Healthcare Fund, and the Emergency Chronic and Critical Illness Fund. It also expands the coverage of its offerings to include in and outpatient care, chronic and critical illness care, primary healthcare access, preventive healthcare, basic treatment, emergency care, and critical and chronic illness treatment. So this is expanding the coverage to essentially provide, or what it is intended to provide, is comparable. I think the intention is that it should be comparable as private healthcare insurance. But when you see the tariffs and the amounts which are covered, there's a whole question about, are you going to receive value? Because noting the rates, which I'll come back to you later, the rates that people are paying and the amounts of coverage, they're quite disproportionate. And those are some of the concerns that have been raised. Now, there's been a lot of court litigation on this, but finally, and just to bring you back to now to start on the slides, on 1st October, the Act became fully operational. So this means that obligations of employers are now mandated by the law. It's no longer a suggestion, so everyone must comply. Next slide, please. And that means that all employees must be registered to the fund. Now, beyond the Act, there were some regulations which were passed this year and also last year. But the ones specific which were passed this year, all employees who are in NHIF and all their details have been, for lack of a better word, but they have been transferred to SHIF. So all employees who are registered with NHIF, their details are with the Social Health Authority. But I would recommend actually to all employers to request their employees to register with the fund. With the authority. The authority does still require additional information from all the employees. Additionally, the Act, as I said, its coverage is much wider than NHIF. So for employees who are not Kenyans and who are foreign nationals, if they're going to work in Kenya, for more than a year, then they are also required to register with the fund. Now, how much in percentage terms or in terms of contributions, how much are employers required to contribute? It's 2.75% of employees' gross salaries. And I want to repeat that, gross salaries. And considering that it is the festive period, some employers are going to be generous and they are going to pay out bonuses, and they want to know, are bonuses going to be factored into the payments? Yes, they are, because it's the gross salary, not the basic salary. Now, the minimum amount that can be contributed per month is 300 shillings. And all of these contributions must be paid to the Social Health Authority. As it is now, they have already given directions and also issued notices of the bank accounts under which these payments should be made. And I want to reiterate this, and if there's anything you can take out of this webinar specific on SHIA, is that this is an obligation now, following all the court litigation. These payments must be made by 9th of every month. So the salaries for October, the payments are due by 9th of this November. So you do, the salaries of October were due 9th of November. The salaries for November are due 9th of this month. So try your best to comply, because there are serious repercussions. If you do fail to comply, then the law provides that any person who fails to comply and make these contributions will be liable, sorry, I'm still here, will be liable to paying a fine of almost 2 million shillings, and they will also be liable for an imprisonment term of almost 3 years. It's not going to be a good way to start the year with having your CEO arrested. So please be mindful of those requirements. Now, for households which are not salaried, because this is important, for households which are not going to be salaried, then they must contribute 2.75% of their annual income. This will be determined by a means testing system. And for those who have managed to interact with the platform on the Social Health Authority's website, as you put in your information, they ask you a series of questions which are meant to determine whether you're financially vulnerable, how much income you're earning, and whether the government should assist in covering those contributions. So this is very important information, specifically for employees who have other dependents in their households. So if they do have a wife, we would encourage, let's say the wife, if she does not have a salaried income, to register also over there. It's just something you can inform your employees. Now, where are we with the court cases? Because this is important, and trying to bring some predictability in a situation which is very dynamic. Now, Kenya's litigation culture, as I mentioned, is very dynamic, and often people go to court, and they go to court where they are of the view that these laws have not met constitutional requirements. So specific to the Social Health Insurance Act, it has been the subject of litigation in the High Courts, and that is why it's had some sort of flickering on, off, on and off. Now, as at July, the High Court declared certain provisions of the Social Health Insurance Act to be unconstitutional. And they had, and this was because of the lack of public participation requirements that are enshrined under our constitution. And to be honest and to be frank, the number of stakeholders in this act, because it also goes on to affect many people's take home. The public participation should have been rigorous. And based on my reading of the decision, there are very many concerns which, in my view, I don't think they'll be resolved even at the Court of Appeal. And one of them is that some of the notices for the Social Health Insurance Act, they were very short. And while this is a well-intentioned act, I'm still concerned with why it was rushed. And this has also frustrated the transitional period and also the implementation. So notices of 2 days, that's just too rushed, considering the number of stakeholders. So the court had given the government time to comply until November, but the government agencies, I don't know whether because of political pressure, went to the Court of Appeal, and the Court of Appeal suspended the judgment of the High Court. And the Court of Appeal confirmed that the government can proceed with the implementation of the Social Health Insurance Act. And that's why the act became operational on 1st of October. Now, there are a lot of questions on this because the litigation is nowhere close to an end. The Court of Appeal may agree with the High Court or it might disagree. But what I do anticipate is that this act is going all the way to the Supreme Court. Now, what does that mean for you and your business? It means that you do continue attending webinars like this because they do provide value and understanding on when the acts are, whether the act is operational or not, and what to anticipate. And it does at least help you understand whether you need to keep a reserve considering all the transitions. So, cutting short, I'll say the act is now operational. As it is now, almost 12.7 million people have transitioned from NHIF to SHIF, and 1,400 healthcare providers are presently providing services under SHIF. Last slide, please. So last word on this, comply, comply, comply. Thank you for that. And I'll now hand over back to William.
Thank you so much, Julie, for that excellent presentation about SHIF and its implications. The next speaker we have is Nelson Otieno, who's an associate at KM Associates. And Nelson is an associate with KM Associates and Course Correct Consulting. He's a legal advisor who balances his knowledge and understanding of the law with innovation and zeal in providing client solutions. His expertise encompasses corporate and commercial dispute resolution and risk advisory, and he has an affinity for startups and business enterprises, especially in the context of financial arrangements and restructuring. He has an experience in managing disputes for both corporate and individual clients and providing advisory services to companies and individuals in employment and labor matters, financial distress, and also turnarounds. He's an alumnus of Aga Khan Group of Schools and a graduate of the University of Nairobi, and a member of the Law Society of Kenya. Nelson is going today to tackle more so analysis of M&M versus G4S Kenya Limited and its implications on the workplace relationships, and also tackle developing policies that balance employee privacy with the professional standards and practical guidelines for maintaining professionalism and integrity in workplace dynamics. Nelson, you're welcome.
Yeah, thank you, William. I hope you can see my screen. I also take note of time, so I'll try to be short and sweet, but still aim to deliver value. So I'm going to be taking you through managing workplace relationships. We will be referencing the G4S case. So just by reference, it was the cause number E232 of 2021. It was a judgment that was delivered on 20th September 2024, and it has certain pertaining implications that would be best to be aware of and also try to implement in the policies within organizations. So managing workplace relationships. it is no strange fact that we spend most of our time in the office. Our statistics actually show that around, on average, a human being spends 90,000 hours in the office, which directly equates to around a third of your entire life. Reasons for this, I personally blame capitalism, but everyone else has perhaps different theories. Now, given this situation, it is no surprise that relationships will develop in the office, and it is also important to be able to have systems in place that manage and regulate this, ensuring that there is respect, there is dignity, and there's professionalism that is maintained in the organization. Now, previous to this case, Kenyan legislation was a bit gray on the issue of workplace relationships. It was not specifically legislated for. And what tended to happen is that most employers in their policies just have an outright ban on fraternization. So just to kind of avoid the entire situation and dealing with it, you just put an outright ban. However, this case has provided some valuable insight, like I've said, and we will go through it. Sorry, can you see my screen?
We can see it, but it's still on the first.
Yeah. So I'll begin with facts, then we shall look into the issues that court considered, and then lastly we'll look into the implications. So facts, for those who are not so familiar with the case, is that Mark Ngugi Mwaura was the claimant. He was employed in G4S from 2000 as a managing trainee. He rose through the ranks until he was the regional operations manager. During this period between 2016 and 2017, he had a relationship with Anne Mukami. And it is during this particular period that one fact is that Anne Mukami got a transfer to a better paying position at Coca-Cola. And when G4S found out about this relationship, or rather it is because of the realization of this relationship that they ultimately terminated the claimant's services on 22nd December 2022. Now, the reasons that G4S gave for terminating the employment relationship was one, sexual harassment. So they were under the impression that the claimant sexually harassed Anne Mukami, who was a junior. And it is also, the second reason was due to undue influence in the transfer. So G4S was again under the impression that the claimant was directly involved in Anne Mukami getting the transfer from G4S to Coca-Cola. Now, other key facts that arose during the hearing rather, was that the claimant made it clear that he admitted having a relationship with the junior, that is Anne Mukami. He, however, stated that the relationship was consensual and it lasted between 2016 and 2017, and it ended prior to the disciplinary hearings. So it is not because of the disciplinary hearings that the relationship ended. Those facts were also reiterated by Anne Mukami. So even though she was not present in court, the court did use the disciplinary hearing records that had been used by G4S, where again, Anne Mukami made it clear that the relationship was consensual and it terminated once her feelings for the claimant had changed or dissipated. Now, given this context, what were the issues that the court dealt with? So the first issue was procedural fairness versus substance. As we are familiar with, unlawful termination boils down to two components. One, what procedure followed during the termination, and two, was there a significant substance or cause to justify the termination? Now, on procedural fairness, the court did indicate that G4S with this particular case did follow proper procedure that is regulated under sections 41 and 45 of the Employment Act, in the sense that the claimant was given a notice to show cause, which he responded to. He was subsequently issued with hearing notice, sufficient time between the hearing notices. Hearing was convened, of which he participated, and he was given chance to have a representative. After the hearing was conducted, he was terminated. The claimant did exercise his right of appeal, and upon appeal, again, a hearing was conducted and it was ultimately dismissed. So the dismissal was retained. Now, in terms of procedural fairness, the court indicated that this was a take on the company. Now, when it comes to substance, that is where the court had a different view. And then this brings us out now to the second component of sexual harassment versus consensual relationships. Because according to G4S, they were stating that there was sexual harassment and there was undue transfer. So the court also had to examine the difference between sexual harassment and consensual relationships. Now, again, this is one of the issues where we do realize that there is a bit of confusion even throughout the trainings that we've conducted for our various clients. One of our key issues when you're talking about sexual harassment is making it very clear or setting the distinction between sexual harassment and consensual relationships. Now, based on the facts of this particular case, both the quote-unquote alleged victim and the harasser both made it very clear on video and in person that the relationship was consensual. And the court did note a difference between consensual relationships and sexual harassment. Sexual harassment has two key components under the Section 6 of the Employment Act and also various case law that has developed over time. One of them being that the act has to be of a sexual nature. And two, perhaps just slightly more pertinent, is that it has to be unwelcomed. So in the absence of these two key components, sexual harassment cannot be connoted from certain acts. In this particular case, like I've said, the relationship was consensual and therefore sexual harassment could not have been founded. So in terms of substance, the first ground of sexual harassment, the court said that sexual harassment was not present in this particular case. Now, on undue influence, during the hearing, that is during the court hearing, the respondent's customer service manager testified. So he was the person who was responsible for transfers for Ann Mukami's transfer to Coca-Cola. He stated that Ann Mukami was transferred because she got the gig because of merit. So she had previously worked as a receptionist and therefore had previous qualifications to embark on this new role. The customer service manager also revealed that or shed light to the fact that even though the claimant was made aware of this, the claimant being made aware of this was purely on procedural purposes, and therefore he did not have any significant direct say in whether the Ann Mukami was to be transferred or not. So again, you find that with undue influence, the court, having interrogated all the facts, made the conclusion that there was no undue influence, or rather undue influence was absent in this particular case. Now, another key consideration that the court had to deal with was the fraternization policy. So a major milestone with this case is that the courts, for the first time, made it very clear that fraternization policies are unconstitutional and they do violate the right to privacy that is under Article 31, the right to dignity, the right to the freedom from inhumane treatment, and also it circumvents the right to be free from discrimination, all of which are provided within the Constitution. With this particular case, the court made reference to Clause 14 of the respondent's HR policy, which outrightly banned fraternization. So the court was of the view that such policies or such measures within an organization tend to be unconstitutional. Now, given all these considerations, the court ultimately had to award damages to the claimant, because so far we found that even though procedure was there, substance was not there, and therefore the termination of the claimant was unlawful. So in this particular case, again, the court awarded 12 months compensation. When it comes to compensation for unfair termination, the court usually enjoys some discretion. So, however, given that discretion, they do not tend to award 12 months unless it's a very serious case and they want to set an example it's more or less rather a punitive measure and an avenue to set an example, even for subsequent jurisprudence in similar circumstances. So the claimant was awarded 12 months compensation because of the fact that sexual harassment is a very serious issue. And even in sexual harassment cases, there are two components that have to be viewed at. There's the victim, who obviously has to be protected and has to be made feel safe for even coming out in the first place. But on the other spectrum, there's also the person who has been accused of sexual harassment. And this is perhaps something that we do not always consider as much as the victim's narrative. And what the court was trying to do was ensure that there is a balance that is struck. So because sexual harassment is a very grievous offense, when it comes to societal, I'm trying to look for the word, but when it comes to the stigmatization is the word. Because if you are found to have been fired on the basis of sexual harassment, you even lose the potential to have future employment opportunities. There's the general stigmatization that comes about. So in awarding the 12 months, the court was telling organizations that before you terminate somebody on grounds as delicate as sexual harassment, make sure that you do have active reporting systems that are in place. You do have active and well-functioning investigative measures that are in place, so that ultimately when you render a decision, it can be seen to have come from a good place, having evaluated the evidence, rather than it being a maneuver to perhaps eject somebody from employment for other motives, be it political or whatever the case. So what is the impact of this decision on organizations? One, as I've perhaps started to allude to, is managing consensual workplace relationships, which is that one advocate for disclosure of the relationships so that you can deal with the main issue that is of maybe perhaps if the job that conflict is made, then you can have clear transfer policies that everyone is aware of at the onset. And even beyond the policies themselves, and a key component is creating a culture that the employees even feel safe to disclose this information. So rather than you can just have the greatest beautiful policy there, but if the culture does not support it, then the policy is as good as non-existent. To ensure that they create a culture over time that allows even the policy to work in place rather than it being a glossy document in the libraries. The second impact is handling sexual harassment allegations. Again, if you do have proper reporting procedures, if you do have proper investigative procedures, that makes logical situations like the GFOS case, where we have seen that GFOS was held liable for unlawful termination based on sexual harassment. So that is the end of my snippet today. Back to you, William. I think we'll take questions next. Thank you.
All right, thank you so much, Nelson, for that excellent presentation. Now we go to the Q&A, and I'll request anyone with a question on the three presentations to either put it on the chat box or also just unmute and ask the questions.
So William, you can display the last slide.
All
the
right.
one with the contact information. Yeah.
So any questions from
Hello.
Yes.
Can you hear me?
Yes.
Okay. My name is Anthony,
Yes, Anthony.
and I'm the senior payroll officer I'm the senior payroll officer of there was some clarification that we received from the SHIF guys, and they were actually clarifying on the gross amount, what amount that SHIF should be deducted from should be from, okay. Ideally saying the deduction from the what we they call regular payments. But now my query is what should we take for as regular payments? Does it mean, let's say someone is getting an acting allowance for 3 months? Can you consider that one as regular?
Thank you for that. Now, I don't know what they mean by regular payments, but I am clear on what the regulations, which are the social health insurance regulations provide, which is that the deduction will be on the gross salary. So to answer your question, based on what is on the Act and not this communique, if someone has acting allowance, then that means that that would constitute part of their gross salary, because maybe they'll receive their salary, and then to their salary they'll have the acting allowance. So the total gross allowance is going to be subject to SHIF, subject to deductions under the Social Health Insurance Act. So that's going to all that gross salary, the acting allowance collated with the basic salary, that gross salary is going to be subject to 2.75%. And if it's a regular payment, and I also consider that to be a regular payment, there's nothing irregular about that. Have I addressed your question, Anthony?
It's because ideally, I can say partially, because ideally you see, based on the discussion I have and my understanding is that ideally it should be anything that, let's say something like basic, that one is basic as in it appears every month, and something else, let's say that doesn't appear, let's say for 4 months, or it appears, let's say for 6 months. So actually what I wanted just clarification is what can we, according to the law, what can we describe by it being regular? Because ideally, things like bonus, which are like one-off payments, those are pretty clear that they should not be included. But now, my query is payments that are being deducted or are being awarded for more than, let's say, 4 months or 6 months. You now just describe those ones as regular.
Okay, I'll have to see the word used on that communique, but from a legal perspective, there's no way that communication or that notice, I'm surprised that they're issuing something like that, can override the obligations under the Act and regulations. It's because in Kenya we have a hierarchy of laws, and after the Constitution we have acts, then we have subsidiary legislation, which is regulations and rules. So whatever communication they have sent out must be in line with the law. And what the law provides is that deduction would be on gross salaries. So that's where I'm finding the challenge. But after this, please have out to the social health authority to understand the basis of such communique.
Okay, I think that's fine.
Thank you.
Thank you, Julie. So we'll take one more question because of our time, and then we'll be able to call it today. So there's a question by Rogers. I have seen some cadres being paid on a daily basis and their salary subjected to statutory deductions. How is SHIF going to be deducted based on this?
Now, from a practical position, I think the first thing is to determine whether that employee is registered with SHIF. Because once they're registered with SHIF, and based on their means testing, then it would be understood how much they're meant to pay monthly. So the minimum amount that can be contributed is 300 shillings. And that's why I want to stress, especially for casual workers, please ensure they are registered with SHIF, because if the minimum amount is 300, then that has to be worked out in those deductions. And if it's more, then again, that has to be factored in the deductions and what their take home would be. So for casual laborers, please ensure they are registered under the Act, and then they provide for you information on how much the statutory deductions should be on a monthly basis. Rogers, I hope that answers your question.
Right. Thank you so much, Julie, for answering the questions. Thank you so much also, Nelson. Thank you, Eileen, Anthony, and Kananu. We truly appreciate also all of us for joining us for today's webinar. And as we strive to redefine the workplace through excellence, let us remember that the true measure of success is not just in what we achieve, but how we achieve it. And through fostering collaboration and also just embracing innovation and upholding integrity, excellence is not a destination, it's a culture that we build every day. So let us go forth and lead workplaces that not only thrive, but inspire greatness in every individual. Thank you for being part of these transformative conversations, and I truly appreciate your time. Thank you so much, and God bless.
Thank you everyone for joining us. Asanteni sana.
Bye-bye.
Thank you and goodbye.